Okay, so welcome everyone, and thank you for joining us today to this masterclass. We are excited, Michelle and I, to be here and have the opportunity to discuss about a burning topic, the Swiss Revised Federal Act on Data Protection, whose entry into force is quite imminent, September 2023. So the question of today will be, are you ready? The main question, the main goal of this masterclass will try to address the key question you may have around this act, and with a special focus on the life sciences industry. If you have any question, do not hesitate to drop your question in the chat, and we will try to address it. And anyway, sometime at the end will be dedicated at the end. So perhaps before getting into the heart of the matter, it could be great to just say a few words about us. So Michelle, I leave you the floor.
Okay, hello everyone, and thank you once again for attending this masterclass. As Aline said, my name is Michelle. I joined MyData-TRUST last year as data protection lawyer, and together with Aline, we work in the Swiss Expertise Group.
And my name is Aline, so I am data protection lawyer as well at MyData-TRUST since more than 2 years, and I am DPO certified. But who are we for those who are not aware of? So MyData-TRUST is a company specialized in data protection and privacy. We are specifically dedicated to the life sciences industry. So far, we are established in more than 5 different countries. US, UK, Belgium, France, Romania, and coming soon, Mexico. Basically, we provide customized data protection services, specifically regarding research activities, clinical trials, and we provide also some support to our clients regarding their implementation of the national data protection laws.
Okay, so the first step is to question why a revision of the Act was necessary. Well, mainly, there are basically 2 reasons for the revision of the Federal Act in Switzerland. On the one hand, there was a need to update the law, which was not revised since 1992, and therefore did not take into account the current challenges of our modern society, for instance, the use of internet on a daily basis. Thus, it was essential to provide the population with adequate data protection laws. And that's what is one of the reasons, because data protection laws currently have to take into consideration the technological and social developments of our current times. Also, Switzerland has been recognized as adequate country by the EU Commission. Therefore, it was essential to align with the GDPR in order to maintain the free flow of data and also to contribute the competitiveness of the Swiss companies. In this context, the Federal Act was adopted in 2020, and 2 years later, its related ordinance was also adopted, which complements the Federal Act in more practical aspects. For instance, on the one hand, the Federal Act sets forth the rights to data subjects, for instance, the right to access. On the other hand, the ordinance sets forth the timeline to answer and handle the request, which is 30 days as in GDPR. They both will enter into force on the 1st of September on 2023. And the question is, are you ready for this?
So, I was saying that the FIDP is not the only solid regulation that applies to the data protection. You have also more than 25 cantonal data protection laws, but we will not talk about this today since we want just to address the processing activities carried out by the private companies. And on the top, you have the sector-specific legislation. Here, as a striking example, you have the Human Research Act, which provides for specific rules around the reuse of the data. So just a little word about the GDPR alignments. You have to keep in mind that the FIDP has been revised to be aligned with the GDPR. However, it's just an almost GDPR alignment. Then you have to still pay attention to the conceptual differences which remain. And one of an example of conceptual differences is already encountered in the scope.
Okay, so who will be impacted? As Aline said, the scope of the Federal Act is mostly aligned to the scope of the GDPR. However, for instance, in the first place, it only covers data of natural persons and not those of legal entities that are currently covered. And this is one of the main differences with its predecessors. As you can see in the slide, we have the three aspects of the scope of the Federal Act. The second is regarding the material scope. This law is applicable to the mentioned data when it is being subject of a processing. There are some specificities, especially for public entities. However, today we will focus only on private companies. Regarding the territorial scope, this is the aspect that differs the most with GDPR. In Switzerland, they have an extensive extraterritorial applicability. The application includes the so-called doctrine effect, which cover processing activities carried out abroad but which have a relevant effect in Switzerland. This includes actual or potential effects. So let me clarify this. So far, neither the case law nor the Federal Data Protection and Information Commissioner, this is the supervisory authority, have clarified this notion of effect. Then, to be on the safe side, we recommend interpreting the notion broadly. For instance, the doctrine considers that the Federal Act might apply to the processing carried out outside of Switzerland when the company processes data of Swiss data subjects. The company, through its activities, might affect the privacy of Swiss data subjects. When a company offers goods and services to Swiss data subjects, and more specifically in the life and science industry, when a company monitors behaviors of Swiss data subjects, this could be the case when enrolling data subjects in a clinical trial. Also, when part of the processing takes place in Switzerland, this could be the case of a laboratory located in Switzerland in our clinical trial. And also when a company uses a server which is operated in Switzerland. The example could be the CRO using a cloud service provider from Switzerland.
So what to expect? From a life sciences perspective, you have to keep in mind that regarding the lawfulness, the Switzerland has opted for an opt-out approach. So it means in practices that when processing some personal data, you do not need to justify your processing by legal grounds automatically, unless you are faced to a violation of the personality of the data subject. What does it mean? If the FIDP has foreseen 3 cases where there is a violation of the personality. The first thing is about the violation of one of the FIDP principle. So what does it mean? It's typically the case where you are not compliant with the data minimization or the purpose limitation. Secondly, you can also have a violation in case you disclose sensitive data to a third party. Here, just pay attention that sensitive data is a notion that is broader than the GDPR. And finally, you can have such violation if you are faced to an express objection from the data subject. But okay, we know when we are supposed to have a legal ground, but which kind of legal ground do we need?
Okay, so as Aline explained, where any of the scenarios previously explained is present in your processing activities, you need a justification for that processing. The legal grounds or legal justification foreseen in the Federal Act are consent by the data subject, provision by law, this has to be a law with effect in Switzerland, and the overriding public or private interest of the controller. The list of private interests is notably long, and here you can find specifically the interest in research. So, when it comes to the legal basis or justification grounds for clinical trials, if the consent is the legal basis, the requirement of being informed, specific, and freely given applies. Also, regarding the private interest of the controller to conduct research, planification, and statistics, the Federal Act contains further requirements, and all of them aim to avoid the identification of the data subject through the data provided for the clinical trial.
Okay, so you have the legal ground related issues, but when you conduct some trials, you can have also some other issue you may face too, like the data transfer. In case of data transfer, what is good news is the fact that Switzerland has adopted the same three-step approach than the GDPR. So basically, when transferring personal data, you need to at the first place, check the adequacy decision. So the adequacy decision so far is a white list provided by the Swiss Federal Council, and it is mostly aligned with the EU. So, for instance, all the EU countries are considered as adequate countries. However, the Japan, for instance, is not considered as adequate, unlike in the EU. In absence of an adequacy decision, you have to check appropriate safeguards. So it will be typically the standard contractual clauses, the BCR binding corporate rules, certification, and so on. And as a last resort, you have the derogation that you may consider in specific circumstances, like the consent. Do not forget that following Schrems case, the Switzerland considers also that you need to perform a transfer impact assessment when transferring your personal data and relying on appropriate safeguards.
Okay, so now we will talk about the further use of data. Further use is the reuse of data collected for one purpose. This would be the primary purpose and intended to be used on a secondary purpose. In cases of further use of personal data, the legal basis must be consent. And this is because the Human Research Act states that consent must be obtained at the time of the sampling or collection. And also, the data subjects must be informed of the right to dissent. And why do the data subjects have been granted with this right to dissent? Well, first, because the consent depends upon whether the material is used in an unencrypted, encrypted, or anonymized format. In the case that it is encrypted, the consent can be for general purposes. However, in case of the use of material in non-encrypted form, the consent must be specific for one project. Regarding anonymization, since this concept is out of the scope of the Federal Act, something we have to bear in mind is that the Human Research Act specifies that to proceed with the anonymization of biologic or genetic data, information has to be provided to the data subject. Finally, the right to dissent or object is foreseen since the obligation to request consent can be absented in three situations. These three situations has to occur cumulatively, and it could be when it is impossible or disproportionately difficult to obtain the consent, when there is no documented objection or refusal available, and when the interest in the research outweighs the interest of the data subject for this further use. But what happens? The next slide.
Yes, just we have a little question in the chat, so perhaps you can just address it and afterwards moving on our next topic. So I have a question. Are there Swiss specificities to consider when relying on appropriate safeguards, typically the SCCs? So yes, we have particularities. So you have to keep in mind that regarding the SCCs, you have two choices. You have the Swiss standard contractual clauses, which are under revision, so not super practical so far. And you have the EU SCC, so the standard contractual clauses that have been released by the EU Commission in 2021. Those SCCs have been recognized by the FDPIC last year, if I'm not mistaken, and provided that you put some Swiss specificities. So the FDPIC, the National Data Protection Authorities in Switzerland, has issued some guidance regarding this addendum you are supposed to include when relying on SCCs. And I think we don't have other questions, so let's move on our next topic.
Okay, so what happens in case of a failure? In Switzerland, a violation of data subject's personality might lead to criminal and civil liability. In case of the civil liability, this applies whether the person acted intentionally or negligently. And this includes employees and other persons integrated in the company who are neither processors nor controllers directly. This could be the case of consultants or agents. As for criminal liability, this applies in case of the violation of the Federal Act and its ordinance. They can reach up to 250,000 Swiss francs, which is about the same amount in euros. And this is a big difference compared to the old Federal Act on Data Protection and also to the GDPR. In this case, fines are generally directed at the responsible individuals. This is the decision makers and/or the managers, and not to the companies. There are only few exceptions to this rule. This means that, in fact, data protection officers can be held liable for non-compliance with data protection obligation. However, for this liability to appear, the actions or omissions must be intentional, and this includes the acceptance of the risk deliberately. Another difference is that supervisory authority does not issue these fines. Instead, the cantonal criminal courts have this competence. The supervisory authority has other enforcement powers, and in practice, they both will collaborate together. Finally, we cannot forget the reputational damage that this situation could bring to the name of our company, having a negative impact.
Okay, so we have definitely to check our compliance due to this big enforcement, which are personal. So how to proceed to be compliant and to be ready for September 2023, sorry. So just a few things before. You have to keep in mind that your action plan will differ depending on you are already GDPR compliant or not. So if you are already GDPR compliant, it will not be that complex to achieve the compliance since you have already all the big notion and the big principle. But you still need some updates, some accommodation of your initial processing. And besides, if you are not already GDPR compliant, you have a lot of work to do. So the main action that could be summarized here are the following. The first thing is about privacy notice. You have to create your privacy notice or to update your privacy notice, depending if you are already GDPR compliant or not. Just pay attention that you have a specific list providing all the information you need to provide to the data subject, but also some information go beyond than the GDPR. So you have really to pay attention to this. Besides, you have the data processing agreement. So according to the FIDP, when outsourcing your processing activities to a processor, you need to implement a contract. And in this contract, you need to check the security measures, but also to foresee an authorization, specific or general, for any sub-processing. Further, you have the data transfer. As I said, the data transfer, you have the same approach, basically, but you need Swiss specificities to implement, basically with the whitelist, which differs a little bit than in the EU, but also with the appropriate safeguard where you need some Swiss specificity, Swiss addendum to implement. You have also the internal procedures and policies. Here, the main thing is that you need your procedures. If you are already GDPR compliant, some procedures are similar. However, others must really be updated. It will be the case with the breach, for instance, since the breach are regulated with a different result and different criteria than in the EU. You need also to keep a data inventory, so-called record in the EU. And we highly recommend you to raise the awareness about the main takeaways of the FIDP through training to your staff. So, do we have any questions so far? We do not have question. Perfect. Let's move on.
Okay, this brings us to the end of our presentation. The conclusion is that compliance with data protection emerging legislation is becoming challenging for companies since there are different laws to consider, and especially in the life and science industry, which is already a high regulated sector. This is exactly how MyData-TRUST can help you and support you, since we are a group of experts specialized in this area. We would like to thank you for your time and attention today. And for more information and interesting news, do not hesitate to follow us on social media pages. We have in the screen our QR codes. And thank you so much again for attending this masterclass.
Okay, so of course a replay of this of our discussion of today will be available directly for those who have already registered to the events, and a replay within a few days will be available for everyone in our YouTube channel. So I think we have a question. Can a DPO be held liable for criminally responsible under GDPR?
Well, as we know, the GDPR has a specific process to address the lack of compliance. However, member states, they regulate, and some of them have specialties into their national legislations to address the same lack of compliance with privacy and data protection. And in some jurisdictions, this lack of compliance could lead to criminal and also administrative or civil liability. However, as we explained in Switzerland, it's a specific, it's different that in GDPR, because it does not lead to administrative liability, but criminal liability, which is quite a specialty of that jurisdiction.
Okay, perfect. I hope it's clear for you. And we have another question, again regarding the enforcement. Which are the case or exception to find the company and not the person involved in the processing?
Yes, in this case, as I said, like normally this criminal liability is put on the place of the decision makers. However, it's true that the Federal Act provides an exception for the case when it's really difficult or it implies disproportionate effort to locate and identify the person responsible. So in these cases, the company can be held liable and will be the one who will take care of the fine. But for this case to appear, it has to be only when the fine does not exceed the 50,000 Swiss francs, which is the same amount in euros. So it's quite difficult to say that it will apply in general. It has this specificity.
Thank you, Michelle. And we have a last question here. How long will it take a company to comply with the FIDP if they already comply with GDPR? Honestly, it depends, because you can be already GDPR compliant, but for 10% or 100%. So it really depends your progress, your advancement in your GDPR compliance. But if you are 100 GDPR compliant, I think it will take perhaps several months just to update, because you have to update your data processing agreement, you have to raise your awareness through a lot of training to your staff, you have to update your policies, you have to check and to be trained regarding data transfer and to update also your privacy notices. So it will take some time, but when you have done the main work, it will be super easy. And I think we do not have other question. So if you have still question, doubt, you need any support, do not hesitate to contact us. through this beautiful QR code. And see you next time.
Thank you.